the whole question of debt bondage as opposed to slavery through debt is what I want to speak about today. And it's important to stress then that these two things are separate, okay, that the debt bondage and slavery through debt are related but separate, as Alain Testard has shown in one of the chapters in this book. If we start with debt bondage, this is something which is particularly associated with South Asia, and Jan Breman, his book on labor bondage in West India, is often cited. Now, it's important to stress that debt bondage is something which is entered into voluntarily. People accept debts voluntarily, although obviously there are certain definitions of how voluntary that is, and also that this relationship is often an informal one, which is not inscribed in documents or and therefore very difficult to take to court. There's also an enormous debate about whether it's a positive or negative, an exploitative or a supportive relationship. And Polly Hill, the late Polly Hill, was the greatest defender of the idea that debt is an absolutely vital resource. And she stressed that in South Indian villages, for instance, the poorest person in the village was a widow without adult children because nobody would lend to her. She was somebody who could not contract debt, and therefore she was the most poor and vulnerable in the village. It's important to note also that the work of bonded people who have contracted debt and are working it off through labor, that they are actually usually paid for that work. It's just that they're paid at below market rates, or very often they don't actually work. They produce goods, commodities, which are paid for again at below the market rate. So the exploitation, if it is exploitation, occurs at the level of kind of exchange, if you like. Note also that it's sometimes possible, but by no means in all cases of debt bondage, to sell the debt to somebody else. So the person can be bonded to one person and then get bonded to another. The main areas of debt bondage in the period I'm looking at since the rise of Islam are shown in this map, which is a very amateur creation of my own. And you can see that there's a very strong tropical focus, that this problem or whatever it may be of debt bondage phenomenon is largely one of the tropics. The obligation ends when debt is repaid by definition, or it can end at the death of the debtor, except that in many cases the debt is hereditary. And in India, it's often the case that the debt is hereditary, so it passes on to your children or to someone else. Gyan Prakash, in this very influential book, argues provocatively, but I think wrongly, that debt bondage was a phenomenon of the colonial period in India. But I think that's complete nonsense, and various other Indian authors have said that it's complete nonsense. Basically, debt bondage is very old in India and in the Hindu tradition in a broad sense. Legislation to abolish debt bondage in India was only taken long after independence in 1976 and has proved extremely difficult to enforce. And it's estimated that today, about 85% of all people in debt bondage are in South Asia, not just India, but a wider South Asian area. Another area where you get a kind of debt bondage is tropical Africa. And this is Falola and Lovejoy's book on this. Pawnship is not exactly the same as debt bondage in the sense that, in essence, what you do is you transfer a member of your family as a kind of guarantee, as a kind of collateral for debt being paid. But it's still, it's quite similar. Another area where you get debt bondage famously is in Latin America, particularly in areas where there are large Amerindian populations, not so much areas where you get either ex-slave or white populations. And this is a book which is edited by Leonie Archer, but she also has a chapter on debt bondage in Latin America. Now, if we move on to enslavement through debt, this map of Alain Testard, if you look at the heavily shaded areas, these are the areas where people are typically not just bonded, but enslaved as a result of debt. And you'll note immediately that these areas are smaller. In other words, it's only a part of the area where debt bondage occurs that debt bondage can also give rise to enslavement through debt. The other point perhaps to note is that it's not just the debtor who might be enslaved, reduced to chattel, status of a chattel, but also his dependents. I say his, in fact, it could be her, of course. And this means that the spouse, the children, sometimes the siblings, sometimes even the parents might be reduced to slavery as a result of an unpaid debt. Note also that slavery could in turn give rise to debt bondage. In other words, you could work the other way around. This is some slaves in Indonesia in the Dutch colonial period, when the Dutch, as a form of abolition of slavery, would turn slaves into bonded laborers. Typically, the Dutch would impose a period of 2 years of labor, after which the ex-slaves had to be freed. This is similar to the apprentice period. If you look at the way in which the British abolished slavery, for instance, in the 1830s in the Crown colonies, they imposed a 4-year apprenticeship. So this is a similar kind of system. Note that also missionaries and even private individuals might redeem slaves in return for bonding their labor. Now you might say, well, what's the point of doing that? And the point, I think, is to do with productivity of labor. Slaves are notoriously very low productivity. Why work? Okay. If you're a bonded laborer, there's some reason for you to work, because you might pay off your debt, you might get rid of the tie. So if we move on to the actual Islamic side of this, so far I've just been looking very generally across the world. Within the broad Dar al-Islam, the abode of Islam, neither debt bondage nor enslavement through debt were thought to be important. And you'll find many books which say this. In fact, many books which say that it doesn't exist, or didn't exist, which is definitely not true. But it's also true that Islam works against forms of control of labor through debt, but not completely. Now, this is perhaps in part because debt is controlled under Islam. This cartoon from 2008 shows you one particular positive view of the Islamic ban on interest on loans, or riba. Other people have a somewhat less positive view on this. Timur Kuran considers that the ban on interest on loans is one of the things which held back Islamic societies and made them poorer over time, because it's prevented the full development of capitalism. Whether the ban on interest actually reduces the level of debt is one of these counterfactuals which is almost impossible, in fact, is impossible to answer, partly because the ban on interest is widely sidestepped. There are at least 4 classic mechanisms by which Muslims have avoided the ban on interest. But also, the ban on interest is not a ban on debt. Okay, you can actually obviously accrue debt in other ways without having interest on loans. And in fact, this you'll see on the right there that debt or dain is one of the things which, if you're free of, you're more likely to enter paradise. So there is a kind of strong ethical, moral push that you should not become indebted, which in turn, of course, shows that it's quite possible to become indebted. It's not in itself impossible. There's also an enormous debate then about whether or not the situation of debt bondage is allowed or not allowed. If you see this hadith, this tradition, it shows again that debt is something which is disapproved of, but it doesn't say, the humiliation, it doesn't say grief and humiliation and that you're forced to work for someone else, okay? So the basic answer of the ulama has always been that this is not legitimate in Islam. You cannot force somebody to work for you because they are indebted to you. Nevertheless, it's equally clear that there's been a lot of debt bondage in Islamic societies. Pakistan is probably the most developed example, and it still continues to be a problem. This is a very recent campaign to try and get rid of debt bondage in Pakistan. The The situation in Southeast Asia is also, Islamic Southeast Asia is also important. And it reflects probably a kind of Hindu pre-Islamic inheritance of this area, but also a widespread flouting of Sharia laws on interest. So in the Maranao area of the southern Philippines, it was reported in the 19th century that a debt alone could double in size in as little as 10 days, which is a sign that the prohibition on charging interest was not being observed. There's also a difference between different parts of Islamic Southeast Asia. Mason Hoadley is the great expert on Javanese law, and under Javanese law, debt bondage is definitely allowed. So this is a case where local law, adat, local custom, or to call Javanese law custom is a bit of a stretch, definitely allowed it. And debt bondage in Java was seen as particularly exploitative, especially in textile workshops. This is a backstrap loom weaver, and we had a lot of these people by the early 19th century who were debt bonded and who were producing for the sultans in Yogyakarta. Another area where you get debt bondage in Islam is actually in the Middle East itself, in the diving for pearls in the Persian or Arabian Gulf. Let's just call it the Gulf, let's just avoid offending anybody. And Matt Hopper has written about this. So this is an area where you get a lot of slaves, a lot of African slaves, but you also get freed slaves and local people who are attached through debt. Another cause of debt bondage in the Middle East itself is, paradoxically in a way, is the Hajj, the pilgrimage to Mecca, which every believer should do in her or his lifetime. But a lot of people rather over enthusiastically rushed off to Mecca without enough money, and therefore found themselves contracting debts and working as debt bonded laborers, sometimes in their area of origin, but sometimes also in the Hijaz around Mecca. Now, having said all that, enslavement for debt was much more common than debt bondage in the Islamic world. And the reason I think for this, as I've tried to show in my book, is that for the ulama, slavery was chattel slavery was the only form of labor coercion which was legitimate in the Sharia. So debt bondage was not legitimate, serfdom was not legitimate, forced labor, convict labor, none of these things were accepted by the ulama, but chattel slavery was accepted, even though the ulama always stressed that the original status of all the sons of Adam, and presumably the daughters of Eve, was freedom. So freedom is the default setting, but slavery is allowed because slavery is a penalty for unbelief. What they don't always add is that slavery is also something hereditary, because if you don't, it's to do with slave as capital, so that the children of slaves are also slaves. So all of this is enshrined in the 6 collections. They're called books, but they're really collections of the hadiths. And one of the traditions of the Prophet and his companions, which are enshrined in these huge collections, or rather one which is not enshrined in these huge collections, is the so-called Swarak Hadith. And the Swarak Hadith said that the Prophet himself had sold a debtor called Swarak into slavery because he could not pay his debt. But the ulama declared that this tradition was weak, it was not acceptable, it had been, in other words, invented, it was a forgery, and therefore it was not included in these canonical collections by the roughly by the beginning of the 9th century of the Common Era. Now, in spite of this, you do actually get enslavement as a result of debt in the history of Islam. And one of the areas in which this occurs, one of the most difficult to deal with, is when people are enslaved for debt outside Islamic countries and then are sold as slaves to Muslim countries. And Ibn Taymiyyah, who's one of the great, normally known today as a great fundamentalist alim, his book here, by the way, Al-Ubudiyya, is interesting because Ubudiyya is based on the Arabic word for slave, abd, but it usually translated as worship and not as slavery. And note the subtitle being a true slave of Allah. So this is a different, this is a metaphorical use of the term slave. Nevertheless, he also did answer a fatwa about whether it was allowable to buy people who had been turned into slaves in the lands of unbelief as a result of debt. And he gave a wonderful, typical sort of answer for an alim, that it was not all right if it was done in lands where the unbelievers had a pact with Muslims, but it was fine in lands where the unbelievers had no pact with Muslims. However, this is a 14th century or late 13th century fatwa. But in the 19th century, Muslims began to be very uncertain about whether it was okay. And particularly this, well, he's not really an alim, actually, he's known as a historian, Ahmad bin Khalid al-Nasiri of Morocco, who said that actually the ways in which the infidel made people into slaves was of concern to Muslims, and that they shouldn't accept them if they had not been done in the correct way according to the Sharia. Of course, the problem was, how did you know how the infidels had enslaved people? You could actually ask them, and quite interestingly, you do have cases where people complain to a qadi, to an Islamic judge, that they should not be slaves because they've been enslaved wrongfully. And the qadi tries to find out, well, how were you enslaved? And do you have witnesses? Unless a person's got some fellow slaves who were witnesses of his enslavement or her enslavement, that's very difficult. But there are attempts to find out. And as early as 1130, Al-Marwazi, who was from Turkmenistan, spoke about the ways in which African children were unlawfully kidnapped in East Africa. So there was some knowledge of how slaves were made, and the fact that this was not compliant with the Sharia. In Sharia terms, you can only enslave somebody in a holy war, and only if she or he refuses to convert at the moment of being summoned to do so. That's in terms of slavery outside the abode of Islam. Within the abode of Islam, you also get a certain amount of, in fact, a large amount of enslavement for debt, even though this was forbidden by the ulama in no uncertain terms. And Bernard Freeman's book, which came out recently in Brill, is probably the best book on this. I would very much warn you against Jonathan Brown's book, which in my view is a very poor book indeed, and ties himself up in lots of knots. Although it is, Brown's book is quite useful in terms of citing a number of authors, but I definitely wouldn't follow his analysis. So the ulama were quite clear about this. You cannot enslave anybody for debt. You cannot sell yourself into slavery for debt. You cannot sell your children into slavery for debt. And it's very important, and this is not true just of Muslims, it's also true of the dhimmi, of the people of the book, the people who are not Muslims, but who live in the lands of Islam peacefully under Islamic rule. So nobody, whether Muslim or non-Muslim, in the lands of Islam is allowed to enslave anybody else for debt. Now, you might have thought, well, that's the end of it. No enslavement for debt within the lands of Islam. But in fact, of course, you get examples of it. Some of them, but not many, from the Middle East itself. This is a particular example where in northeast Iran or Persia, people sold their girls into slavery in order to pay their taxes. And it's quite interesting, actually, the way in which taxes and debt are often connected. You need money, you need cash to pay your taxes. How do you get cash? Sometimes you sell your girls. But the important point about this is that, as far as I know, everywhere in the Middle East that you do get enslavement for debt, it's seen as wrong. So that, for instance, the people in this case said, yeah, well, we know it's wrong, but how else are we going to pay the tax man? In Africa, in contrast, there is a much more common allowance of the phenomenon of enslaving people through debt in Islamic Sub-Saharan Africa. And this is, in fact, at times enforced by sultans. Indeed, Muslim rulers would at times in Africa even seize their own free subjects and sell them into slavery in order to pay their own debts. So the sultan's debts were paid by seizing people and selling them. But even though this was common in Africa, it was also known to be wrong. So that when you get the great jihads in the mid-17th century to the late 19th century, one of the things that the jihadi reformers in West Africa do is to get rid of this system. In particular, we have the example of Al-Mami Sori of Fouta-Djallon, today in Guinea-Conakry, who specifically freed Muslims who had been reduced to servitude, to slavery as a result of debt. There's an interesting sort of postscript to this, in that Al-Mami Sori then said, well, on the other hand, it's not very good that these people didn't pay their debts, so they should be beaten. So people who don't pay their debts should receive physical corporal punishment. And this is interesting because it is not allowed for in the Maliki school of law of Sharia, which is prevalent in West Africa. So in other words, you're remedying one breach of the Sharia, but you're actually introducing another one at the same time. Now, if we turn to India, or South Asia, where we've seen as a major center of debt bondage, we also find that Muslims were owners of large numbers of slaves who had been enslaved for debt. The British, who were very keen on making lists and recording everything, and tried to work out how many slaves had been recruited, how many people had been brought into slavery through debt, and considered that this was in fact probably the largest number of slaves of Muslims were from a indebted background. One of the ways in which this happened was through Muslim rulers enslaving tax defaulters. This continues right through the Mughal period, and this was justified by public interest and the rights of sultans basically to do what they want in terms of qanun or statute law. There was also, however, another interesting form of debt, probably more common certainly by the 19th century, which was debt through self-enslavement and the enslavement of your children in cases of famine and other natural disasters. Now here, what we get in South Asia, which is very unusual, is that the old Swarak Hadith, which had been rejected by the ulama in the Middle East and was generally rejected through Islam, is here resurrected and is here said to be a sound and acceptable hadith. And therefore, it was okay, since the Prophet had sold into slavery someone who was in debt, it's okay for South Asian Muslims to do the same. And this is the rendering by Macnaghten of this particular work. Now, note that on the third line, Macnaghten says that the Mohit-u-Saraksi is a work of unexceptionable authority. Right? This was a British view. Many South Asian Muslims disagreed and said it was actually a very bad book of Islamic law and one that one should not follow. So this is actually a contested area as to whether this book of law was actually acceptable. If we turn to Southeast Asia, we find again very high levels of indebtedness and very high levels of slavery through debt, probably the highest levels of slavery through debt anywhere in the Islamic world. And here, colonial officials certainly believed that the most common origin for a heritable chattel status as a slave was indebtedness. And in Southeast Asia, this was made worse by the fact that the Sharia rules were not respected on interest rates, as we've seen earlier, very high interest rates, but also on gambling, which is forbidden by the ulama, and on animal fights on which people gambled, particularly cockfights was one of the things that people gambled on most. So in other words, you're breaking 3 Sharia laws in the process of getting people very heavily indebted and then through debt into slavery. Now, in the case of Southeast Asia, this enslavement of debtors was justified in terms of adat, that is customary law, and this is one of the oldest texts of the a version of the Undang-Undang Malacca, which was the original code of law of the Malacca Sultanate after conversion to Islam, which is a kind of mixture of Sharia, but also of Sultan's law, Qanun, and of adat, of customary law. And these laws then, these Malay laws specifically allowed the enslavement of debtors, albeit with certain limitations which varied a little bit. The 18th century code of laws, the Luaran Code of the Southern Philippines, was even more explicit in that it allowed the sale of children by parents. So this is a further development, although the Luaran Code is in fact based on the laws of Malacca, like all these laws. However, in Javanese law, and we've already seen that Java is very odd in Southeast Asia, but it also contains most of its Muslims, about 2/3 of its Muslims. In Java, it was absolutely forbidden to sell anybody into slavery for debt. So Java goes against the Malay or South Philippine tendency. So it's quite important to note that customary law varies a lot in Southeast Asia and that the effects are different. Finally, then, in China, enslavement for debt was extremely common. We don't tend to think of China as a major slave-owning society, but there were probably far more slaves in China than there ever were in all the Americas under colonial rule. Okay? We're talking about millions and millions and millions of slaves in China. It's something which is often swept under the carpet, and of course the present government in China doesn't like to talk about it at all. Much of this was child slavery, so children who were sold into slavery for debt. And so this, in a sense, is quite like India, with a very high proportion of debt originating slaves. However, it's also true that Chinese emperors, Chinese dynasties were opposed to this phenomenon and passed legislation, various kinds of legislation, to stop it happening. So that what you get is a kind of typical Chinese compromise, that people bought children all the time, but they pretended it was adoption. So you adopted the child that you bought, and that made it okay in terms of Chinese legislation. Now then, for Muslims in China, of course also numerous, this raised a particular problem because adoption is forbidden by the Sharia. You cannot adopt in terms of Sharia law, although you can foster. But because adopting means somebody losing their lineage, and lineage was terribly important to the Arabs of the Arabian Peninsula, adoption per se was forbidden. This actually led to a very strange situation where in Turkey, when Atatürk abolished Sharia law and went over to secular law, adoption then became possible, and Turkish slaves then became adopted instead of being slaves, because they were no longer able to call them slaves in Sharia terms, so they called them adopted children in the new civil code that Atatürk adopted. This was applied to many Armenian children because at the time of the Armenian genocide, many Armenian children, women and children, were taken into slavery in Turkey. Sorry, this is a diversion from China. Let's just get back to China. This is the case of the Muslims of northwest China, of Gansu, that Jonathan Lippmann looks at. And we know that in the 18th and 19th centuries, when the Hui Muslims, that is the Chinese-speaking Muslims of China, were prosperous and doing very well as traders, they probably bought a disproportionately large number of child slaves from their non-Muslim co-nationals. But they also had to pretend that they'd adopted them. They didn't like it because of the problems of transgressing Sharia law. And so they tended to settle them in annex villages as junior and dependent lineages. Now, the Chinese state became worried about this because it was increasing the number of Muslims extremely fast. And so when there was a big Muslim uprising in northwest China in 1784, after the rising had been put down in considerable bloodshed, the emperor decreed that the Hui Muslims were no longer allowed to adopt anybody. I mean, this obviously was impossible to enforce, but it's interesting that the imperial authorities saw it as something that needed to be done. In the 19th century, when you move into it's called Sharia-minded reform, the enslavement for debt became a bugbear of reformists. They began to see it as one of the main ways in which the Sharia was being transgressed by Muslims all around the world, and they said that it should be stopped. Indeed, as should also the various other transgressions of the Sharia which led to people becoming indebted in the first place. Interestingly, then, they stressed the forgiveness of debt as being an Islamic virtue. Here we have a citation first from the Quran, and then a citation from one of the Hadiths saying that you should be generous, and indeed you should perhaps simply cancel the debt if necessary. And this in turn led to a strange alliance between Sharia-minded reformers and colonial reformers, because colonial reformers jumped on this. They preferred to try and deal with slavery through indigenous methods rather than by imposing colonial laws, which would be very unpopular, which would result in rebellion, as for instance in the southern Philippines, when the Americans abolished slavery in the southern Philippines after taking over from Spain. There was a massive Muslim rebellion against the Americans as a result. So instead, the colonialists preferred to work through these Sharia-minded reformers. And in 1809, the muftis of the East India Company issued a fatwa which said that enslavement for debt was completely forbidden in terms of the Sharia. And fascinatingly, enslavement for debt was completely forbidden both in the lands of Islam, in the Dar al-Islam, and also in the lands of unbelievers, in the Dar al-Harb, the land of war. And this is the first text I've ever come across which actually forbids enslavement in the lands of unbelievers. Now, to what extent this fatwa was inspired, drafted, it was certainly encouraged by the British. But I would say that it certainly its terminology, I think, is not British dictated. This is something which is written in Islamic terms by Islamic scholars. But it's also, of course, enforced through British authority, enforced to some extent anyway. And it's interesting to note 1809 is many, many years before the British declared the status of slavery not to be justifiable in court in 1843 to 44. So some nearly 40 years before this, the British were already trying to work through the Islamic system in order to get rid of slavery before biting the bullet and actually making it not exactly illegal, but refusing to recognize it in law. And this kind of strange alliance between Islamic reformists and colonial officials of a rather liberal bent, because some colonial officials thought slavery was rather a good thing. So we're talking about reformist Muslims and reformist colonial officials. This alliance is something which you find throughout the Islamic world, throughout the areas where there are colonies, Southeast Asia, Africa. There are many examples of this as well. So in conclusion then, I would very much encourage you, if you're interested in this topic, to look at this book edited by Gwyn Campbell and Alessandro Sanziani, in which first version of this talk I'm giving today actually was published, but there's also a chapter by Edward Alpers on East Africa and so on and so forth. So this is a good place to go to see more about this. And basically what we have is a situation whereby debt peonage or debt bondage was rejected by the ulama, but occurred sporadically where the Sharia was weak and where customary law allowed it. And I should say customary law, this is the traditional term, ada or urf, but it means a lot of different things. It often means the legal system in the lands that the Muslims conquered. So for instance, in Syria, ada would actually be Roman law. And in Java, again, ada is actually Javanese law. So you mustn't think of this in terms of tribal custom or local custom necessarily. This term customary law covers a lot of different things. Right. Unredeemed debt leading to chattel slavery was also banned by the ulama, but I would argue was quite a lot more common. And this was basically because slavery was a legitimate status in Sharia law. So you knew what you were dealing with. Once you put somebody into slavery, you had a good set of laws to deal with them. If you look at the main Islamic code of laws in South Asia in the 19th century, about a third of the entire text deals with slaves. Right? So this is not a marginal phenomenon in Islamic law. It's a very developed phenomenon in Islamic law. However, it still remains that as far as the ulama are concerned, you shouldn't make a debtor into a slave. So there are three main factors I've been arguing which conspired to some non-compliance, not necessarily, not general non-compliance, but the first one of these is this evasion of the spirit of Sharia law, perhaps not of its letter, by importing people who had been made slaves outside the lands of Islam. This is something which the ulama debated. It's very unclear whether this was a breach of Sharia law. Secondly, by disagreements over the Swarak Hadith, certainly in South Asia, this was important. Was this a valid or not a valid tradition of the Prophet and his companions? But mainly because of the space given to customary law, which in effect created a situation of conflict of laws and of the enslavement of debtors. Now, the position of the Sharia on customary law, so-called customary law, is basically that it is a subordinate system of law, so that it is allowed to exist, but it must not conflict with the Sharia. That is a statement, an idealistic statement, but one which often didn't actually work. And as we've seen, people often were in fact enslaved to debt as a result of local so-called customary law. Thank you.